we have another interesting session coming up, which is on the magic formula in arbitration. So a magic pill. And may I invite on stage Mr. Alex Heck, ESQ attorney at law and INBA's International Secretary Chair from Germany. May we have a huge round of applause for all of them. Mrs. Lata Krishnamurti, Supreme Court Advocate, Law Chambers of Ram Jethmalani ji. Ms. Andrea Holíková, Director of Department of Specific State Operations at Ministry of Finance of the Slovakia Republic, and Mr. Rajat Taimni, partner Tuli and Company. The stage is all yours, Alec. And maybe the timing till about 1:15.
Which I think you and hope you will find to be rather exciting, already from the fact that it is a rather unusual topic, ex aequo et bono. Not everybody, I think, knows what this means, especially in the resolution of arbitration proceedings. But first of all, I need to apologize for the fact that 3 of our originally invited panel members are not able to make it here to Delhi. They're coming from Europe. They were supposed to come from Europe, but they couldn't, not because they may have been demonetized, but because of the strike, once again, of the poor pilots of the German airline Lufthansa. So here we are, the 4 of us, but as you can see, I think a very well-balanced panel, gender-wise, ethnically, age-wise. So before I introduce the topic to you, I think it will be appropriate to first see where we all stand with regard to dispute resolution and in particular arbitration in India. As you all know, a great effort has been started already last year and before last year to modernize the Indian arbitration system so that it gets on the world map. Because so far it was, just a blank space. Nobody, especially clients from or companies from abroad, wanted to go and litigate, and certainly not litigate, but also not arbitrate in India. So may I ask Lata Krishnamurti to perhaps first of all introduce yourself, if that is necessary, a little bit, yeah. And then Rajat would also comment on it.
Just introduce myself now, and that's it, or just also go into the subject? Just introduce, or also speak?
Me?
No, for me, just to introduce or also to speak on the subject? Okay. Hi, everybody. My name is Lata Krishnamurti, and I practice at the Supreme Court. I'm also involved with the Indian National Bar Association from its very inception, from the time it was born. And I have been attending most of the seminars that have been held here since the last 5 years. I am laying emphasis on the Conference on Law and Policy Issues. And my thrust at the end of this, my little presentation would be to emphasize on that. You see, there isn't very much material in the Indian, literature and law on ex aequo e bono, as a method or principle of resolving disputes. The earlier Act of 1940 didn't even mention this principle, but when they made an effort to bring the new Act, which is the 1996 Act, in line with the UNCITRAL, they introduced this clause in Article 28, where it says that where the parties expressly agree, there can be, any dispute that is submitted to an arbitral tribunal can be decided by applying ex aequo e bono. And the UNCITRAL tribunal itself at 35 talks about this very same principle, where it again talks about expressly being authorized to apply this principle to resolve or sort of settle or decide a dispute. But in addition to stating this in clause 2, the UNCITRAL goes on to say, in all cases the arbitral tribunal, in all cases, that means even where aequo, ex aequo e bono is applied, the arbitral tribunal shall decide in accordance with the terms of the contract, if any, and shall take into account any usage of trade applicable to the transaction. In other words, the anxiety, and the reason for this to not become very popular in this country is that people believe that once a dispute is given to an arbitral tribunal and the principle of ex aequo e bono is used as a method of deciding the dispute, the entire Indian law or any other law of the contract would be completely, it will be in derogation of it or completely bypass that law, and it will be something very whimsical or subjective, which is a very, very foolish old belief. And the English, I must say, till almost 10 years ago, firmly believed this. Even very important writers had decried this thing on precisely this ground, that it does not respect the law of the country, and this is going to be something that will lead to a lot of subjectivity. In 1938, when the Statute of International Court of Justice was framed, in the statute there is a very specific provision again, which says at Article 38 that the principle of ex aequo e bono can be used, if the parties so agree. So there is no harm in using this principle if the parties want it. Only in recent times there's a clearer understanding of the concept of what this is, ex aequo e bono. It means fairness guided by the terms of the contract, and also taking into account international customary law, usage and practice of the trade in practical and reasonable way. It is very, very desirable method of settling or deciding international disputes because it is more expeditious and very, very practical as compared to, delving into and interpreting various laws in an environment where there is mutual distrust of the local laws of any state. When you want to supplant the law by your own law or the law of the foreign country, I'm only talking in reference to international contracts, the basis of all that is a distrust of the host country's court system as well as the laws of that country. So they say that no, the contract will be this will be the law, the jurisdiction will be of these courts, the procedural laws will be this. So now 3 different laws the arbitrators have to grapple with. Now what if we set it aside and decided that it will be on ex aequo e bono? It's not that you completely disregard the law, but you see how practical it is. Now this is not something new that has happened in the recent years. This law has been there for a very, very, very long time. It's based in antiquity. The lex marcatoria was a system of law that was used by merchants to resolve disputes. And they say that in those days, people had no time to wait and decide the dispute. On the go, the disputes were decided by using whatever was the applicable trade practices and customary law. So that way, they had an expeditious decision by people who knew what the trade practices were, and it was cost effective. It didn't mean having to wait forever. So this was how it was very, very popularly used, and then somehow it came into disuse, but once again it has been used. It's come into use, and it's very, very relevant to use it in today's time. There was a very beautiful article I read by Leon Trackman, a big professor of law and a former dean of the Faculty of Law at New South Wales. He's also a visiting professor at the Madison, Wisconsin University as well as at the University of California. The gentleman has written a law in the Chicago Law Journal where he says the law on a subject is still whenever this principle can be very effectively and gainfully used wherever there is a dispute in a subject which is in an emerging field where the law has not been properly crystallized. In such cases, you should have it. Or where the parties have been having long-standing relationship, and this is just a little hiccup that has developed in the meantime, but they want to resolve it and move on and continue with their practice in the future as well. Now, in such cases, they say the most desirable method of deciding such arbitral dispute problems would be through arbitration, where you apply ex aequo e bono as a principle of decision. It will be a very good, desirable thing. And now with globalization, most countries invest in foreign countries. When you feel that these investment treaties should be, there can be disputes that arise out of the investment treaties. Now in these cases, again, ex aequo e bono is an excellent method of deciding the dispute for two main reasons. One, it's practical and cost effective, and second, it's very, very expeditious as compared to the other methods. Why? Because it completely shuts out and debunks any kind of appeal to other courts. The judgment or the award is passed on the material, and there is no question of law as such that arises, which needs to go to, a court of law to be decided. So as far as possible, court litigation is avoided. We've seen the bilateral treaties of India, Britain, some of these countries, where you see that, one of the preliminary condition is that you will have to first exhaust your local remedies, and then you have to submit yourself to mediation by a third party. It's only after you've done these two steps, which is again a very, very time-consuming and very, very expensive two steps, only then can you even think of having an arbitration in the proceedings, and then all this thing starts. Parties appointing an arbitrator and all of that. And there is no time limit really prescribed, at least in the treaties, which we have seen. What I was suggesting was the host country like India, for instance, which has such a backlog. On the one hand, we say make in India, like I see here. Now, this is a policy matter. Now, you don't want to burden a country which is interested in investing with you. We, on the one hand, go and ask people to invest in the country and then make it so onerous that nobody would want to come and get embroiled in all these court disputes in this country. So the better way in such cases would be to completely look away from the bilateral treaty agreements and then look to ex bono, ex aequo e bono, as an excellent tool to settle disputes. Realizing all this and recognizing this, they started, there was a convention in October 2066, is it? Yes, October 2066, when 20 countries came together and said, these were all members of the International Bank of Reconstruction and Development. They started a center. The center was called the International Center for Settlement of Investment Disputes. Now, this was in 66. So it started with 20 countries, and today, when I take the statistics of 15th December 2015, there are as many as 196 countries that have signed this convention. But India, which has been hollering, make in India, I'm afraid is not a party to this center. Now, why would it be important to become a member of this convention? Because it only allows disputes to be settled between member states of foreign government and a member state. Now, once this is done, what happens is they have this ex aequo e bono principle enshrined. Of course, if the parties so agree, to settle disputes. So when they settle disputes by this method, what happens is you don't have any kind of appeal. There are two systems of settling. One is, of course, one of the methods is conciliation of disputes. The other is through arbitral proceedings. There's an arbitration tribunal which is available under the Act, where you only get, very, very short time. At every stage, the time is limited to something, 20 days, 30 days, whatever it is for the notice period. If you will have to see the rules. And the rules are very, very easy to understand and very simple. So they say that the whole thing, there is no appeal against the award given, and the award becomes final unless there are two provisions made, which is very, very rare, where you say, for instance, that, there was some data which was kept back or which was not discovered at the time when the award was made. Then you move under 51 or 52 of the convention to say that we've discovered this, but even then it has to be done within 90 days. And under no circumstances can an award which has been given and which is over 3 years old can be touched on any ground. Now this thing will be reviewed by the very same tribunal which saw the earlier one. And where you may cast aspersions against the arbitration tribunal itself, you say that somebody has been corrupted or somebody, indulged in some malpractice, didn't disclose something which he ought to have. Now, those things are examined for annulment. Then you ask for an annulment of the award, but those are examined by another tribunal also to be constituted under the convention, and it's decided. And by whichever way you look at it, it will be an excellent idea for India to become a member of this convention, because our Indian courts are unable to even cope with the, with the laws and, the backlog of cases that are already pending. And therefore, it is important to inspire confidence in our investing countries and companies from abroad to become a member of this convention, and to say that, I'm very surprised because this government was it amended the Arbitration Act as soon as it came. Then it created all these commercial courts and everything. Now, this is something that they should have definitely seen and done something about, which they have not done, instead of which we only have this awful bilateral treaties. The guidelines which are given there are extremely onerous, and I urge many of the delegates who come from other countries to, to sort of pressure the government of India or persuade the government of India to become a member of this convention, so that it becomes easier to, to kind of find a forum that will give them expeditious relief. Thank you very much.
Well, thank you, Lata. You raised a few very interesting points, including on the subject of investor-state arbitration, and we have Andrea here to comment on that and give us her tremendous experience she has in this matter. But before we do that, I invite Rajat to comment himself on the Indian side in particular, but feel free to add whatever you wish to.
Good afternoon all. My name is Rajat Taimni. I'm a partner and head of dispute resolution for Tuli and Company. I hope everybody at the back can hear me.
No, you must speak in the mic, I think.
It's a very interesting and unorthodox topic, and as Lata ji has already mentioned, there would be, in the Indian context, you would struggle to find a lot of narrative or reference in relation to the concept ex aequo et bono. But however, this presents for us a very interesting opportunity to consider the concept, and what I propose to do today is three things. I just want to highlight...
So use the mic.
I just want to highlight, in our view, from an Indian perspective, what the concept means, how the concept has been applied, and some key challenges one might face if once the application of this doctrine, there are awards which are based upon the application of this doctrine. In the simplest sense, the concept means that parties to an arbitration dispute expressly agree that the arbitrator would not be bound by the strict rules of substantive or the applicable law, and would be free to give effect to the general considerations of equity and fair play in giving the award as far as the arbitration is concerned. So practically, what does ex aequo et bono mean? How does an arbitrator who has been empowered in this manner act? It could mean a number of things. It could mean that the arbitrator has the ability to decide a case according to his own subjective sense of justice and fair play in making a decision on the dispute in the peculiar facts of the case. He has the freedom from being wholly bound by each and every aspect of the applicable law, including the substantive and the procedural law. He has the ability to ignore, or the freedom rather, to ignore certain contractual provisions and trade usages if he so likes, and if he feels that that is what is equitable in the circumstances. He can decide on a basis which is apart from the law. For instance, he can use the unit droit principles, which is the International Institute for the Unification of Private Law, in arriving at his conclusions. As Lata ji also mentioned, it is not that the arbitrator, whilst acting ex aequo et bono, has to completely disregard the law. In fact, there are two schools of thought, one of which says that the arbitrator should, in fact, engage in the exercise of seeing how the applicable law is relevant as far as the facts and circumstances of the case are concerned, and whether they do produce an equitable result. And the ICC task force on ex aequo et bono arbitration says that the arbitrators should be encouraged to adopt both these approaches, in the sense of using the applicable law as a guideline or as a yardstick, and if he feels that no equitable result would arrive at because of the because of the peculiar facts and circumstances of the case, then he's free to ignore the applicable law and use considerations of equity and good conscience in arriving at a decision. In as far as the applicability of the ex aequo et bono in practical cases is concerned, having looked at some research on this, there was a case involving an Argentinian and a Chilean company. And even though the parties had based their claims under Argentinian law, it was agreed between the parties that the tribunal would act ex aequo et bono, and it applied the sections 4.6 of the unit droit principles, and on that basis decided that the contract which had been drafted by the buyer, its provisions would be interpreted in a more favorable manner to the seller, which is the contra proferentum principle. But that principle, the application of that principle came about because the arbitrator was acting ex aequo et bono rather than under the Argentinian law. There was another arbitration where the application of the applicable rules would have resulted in the invalidation of certain contractual provisions. Again, the parties at that stage agreed that it would be in the interest of justice that the arbitrator should act aequo et bono. And in the circumstances, because the parties wanted to arrive at a fair decision, they allowed the arbitrator to ignore the contractual provision and therefore coming at a more balanced and fair result. In another case, which involved a distributorship agreement between a company from Panama and a company involving Puerto Rico, the arbitral tribunal, acting as in the capacity of ex aequo et bono, affected or implemented the equitable quantification of the loss as far as damages were concerned, relying again on the unit droit principle rather than on a particular statute or law. Just very briefly again on the prerequisites for the applicability of this doctrine. The first and the condition precedent is that the parties must authorize it. Under Indian law, as Lataji mentioned, you have section 28, subsection 3, which says that the parties expressly have to enable the arbitrator to act as ex aequo et bono, and that is something that comes from the UNCITRAL, and it is replicated across all the major leading arbitration systems and national law. The second and the equally important issue is that it is not only the parties at a contractual level who have the say in the matter, but the national law as well must provide for that. For an arbitral award to be valid and enforceable under the principles of, using the principles of ex aequo et bono, it has to be authorized by the relevant national law, which in our case, in the case of India, has happened in the form of section 28, subsection 2. Just on this topic and given the Indian context, after the amendments to the Arbitration Act, even though not strictly in the same sense as ex aequo et bono, the Indian context for the first time has imported the fast track procedure, which is the expedited procedure, which allows the parties, if they so agree, to do away with the technical formalities. It allows the parties to choose a sole arbitrator instead of having 3 arbitrators, which in some cases generally tends to become a more expensive and time-consuming process. The arbitrator is permitted by law, by the amendments to the Act, to decide the case solely on the basis of the written pleadings and the submissions made between the parties. There is no necessity for an oral hearing to happen. And if the oral hearing happens, the arbitrator is authorized by law to dispense with any technical formalities. And the timeline which is given for the award to be handed down is 6 months. So whilst not entirely within the realms of ex aequo et bono, we can see that the need, as Dr. Axel mentioned as well, that the need for India to be seen as being part of the international arbitration community, in that there have to be defined and reasonable timelines within which the award must be rendered, that has been recognized, and that is something that has now been provided for under the new Act. The coming now, the final sort of narrative as far as I'm concerned would be the we have the ability under the Arbitration Act, we have the intent, of course, in that commercial parties want to have their disputes resolved expeditiously. This has to do with the legal landscape in terms of, at the end of the day, what is it that we want as far as an arbitral award is concerned? We want the award to be handed down within a reasonable time frame, and we want the award to be as valid and enforceable as possible. Now, how is an award valid and enforceable? We have to go back to Section 34, which is the setting aside provisions as far as the Indian Arbitration Act is concerned. The challenge, as far as I can see, is whether an award which is rendered according to the principles of ex aequo et bono would comply with the Indian yardstick of public policy. Now, public policy has been, it is like the concept of socialism. It is, many things to many people, even though there has been efforts by way of the amendment to streamline the meaning of public policy. But for instance, there have been judgments from the Supreme Court which say that the fundamental policy of Indian law is part of public policy. And as part of public policy, the arbitrators must adopt what is known as a judicial approach in the matter. Now, whether or not a judicial approach, which basically means that the arbitrator cannot be, he has to be objective, his award has to be reasonable, it has to be based upon an application of mind. All of these considerations have to be examined before an award, whether an award was to be set aside or not is to be made. Now, whether or not an award which has been rendered in the context of ex aequo et bono would satisfy the tests of Indian public policy is something of a challenge. I mean, I have only been able to locate one or two cases where the Indian high courts have said that even in the application of ex aequo et bono, the substantive law cannot be ignored, the principles of fairness cannot be ignored. And in that light, I suspect that it is very interesting times for us. There have been amendments that have been made. There is a great push by the government as well as by the judiciary to make the Indian arbitration scenario in line with international standards. And the applicability of the principles of ex aequo et bono provide that opportunity to expedite the process and to ensure that commercial disputes are resolved in a reasonable manner and and the award that is eventually handed down is valid and enforceable. That's all I propose to say. Thank you very much.
Thank you, Rajat. That was all very interesting, and I'm sure we will revisit some of the things you said as well as the things that Lata said. But before we do that, and before I perhaps share with you some practical experiences as far as sitting as an arbitrator applying ex aequo et bono, I have the great pleasure of turning to Andrea Holíková from the Slovak Republic. She's there with the Ministry of Finance and acts there as director of the Department of Specific Legal Affairs. And in fact, she is a real star to me because they had 11 investor-state arbitrations where she represented the state, and all 11 cases they won. So what else can I say? But congratulations, and we're looking forward to your presentation.
Thank you very much. Just maybe at the beginning to explain what investment arbitration means, to have maybe a broader concept of ex aequo bono principle in the context of the international public law. I'm a head of the legal team of the Slovak Republic. I'm in charge of the defense of the country against claims brought by foreign investors against the state under bilateral investment treaty, also called Agreement on Mutual Protection and Promotion of Investment. The claims are routinely for hundreds of millions, sometimes millions of dollars, and are challenged usually the state legislative, executive, and also judiciary acts. The claims also involve important question of the public policy, the most pressing social issues of the days, and if the state loses, public funds have to be used to pay the damages. So that's why the investment arbitration claims are very, sensitively monitored by the public in the Slovak Republic. Maybe you heard about the largest investment case in the world, like the Yukos versus Russia. So this type of cases are in my agenda. So I will try to explain the ex aequo bono principle within the context of international public law. My colleagues already explained to you the definition of ex aequo bono, so I will not repeat it. I just, say that ex aequo bono decision means a decision on the basis of equity, which means in deciding the case, the arbitral tribunal would seek a fair and equitable solution. You may heard also a synonym to ex aequo bono arbitrator, amicable composition arbitrator, but the terms are more or less the same. In both situations, the tribunal is empowered to disregard the strict application of legal rules and to refer to equity. So ex aequo bono arbitrators may rule on claims even they are brought in violation of statute of limitation, extend the evaluation of damages to indirect damages, and award interest other than provided by contractual terms, may differently, assess the burden of proof between the parties and other features in the arbitration proceeding. This concept is usually chosen by the parties as a substitute for not an addition to national law. It therefore sometimes is viewed or called as a negative choice of law, as the arbitrator is appointed to apply the equity and fairness instead of a specific national law. Furthermore, being released from application of the law, arbitrators authorized to decide ex aequo bono may resolve the case by recourse to general principle of law or other non-state rules of law, such as like mercantoria, or as my colleague speakers already mentioned, or the UNIDROIT principle of international commercial contracts. The important issue of ex aequo bono principle is the power of the arbitrator. The arbitrator's powers to decide as amiable compositor or ex aequo bono arbitrators finds its limit in the will of the parties and in the public order. The admissibility of ex aequo bono resolution in different legal systems does not mean the power of the arbitrator is viewed as unlimited. Just as a decision at law, the respect of substantive and procedural public policy is mandatory. No matter the authority conferred on arbitrators, the states, the sovereign, cannot tolerate that the conduct or result of an arbitration violates public policy, so as the party autonomy cannot prevail to the detriment of the public interest. Unlike a state judge, the arbitrator is not bound by the public policy of the particular country. Paradoxically, this does not mean does not make the job easier, because the arbitrator must follow three different public policy that could influence the validity and enforceability of the award, and that it's substantive law applicable to the dispute, the law applicable of the place of the arbitration, and that of place where the award may be enforced. Despite differences in the definition of the public policy among legal systems, the notion of public policy operates as a limit to the authority of amiable compositor or ex aequo bono arbitrator, and must be respected nearly in every jurisdiction. Otherwise, the award may be nullified or annulled, or its recognition on enforcement can be refused. On the contrary, it is generally accepted principle in international arbitration that the paramount duty of the arbitrator or ex aequo bono arbitrator is to apply the contract of the party unless it shows that the provisions relied on are clearly against the public true will of the parties, or violate the basic commonly accepted principle of public policy. Now I will touch briefly again the autonomy of the parties, which is just requirement number 1 for application ex aequo bono principle. Ex aequo bono decision represents an extension of the widely recognized principle of party autonomy and contractual freedom. Therefore, not only may the parties agree on applicable rules of law to the relationship, but also they may authorize the arbitrator to decide on basis of equity, which means beyond the law. Its legal nature is that of waiver. Just as the arbitration agreement is a waiver to the submission of the dispute to a state court, the amiable composition on ex aequo bono adjudicator clause is a waiver of the right to have the conflict resolved pursuant to law. In case of an agreed choice of law, normal way to agree on the decision ex aequo bono is to include this provision in the initial arbitration clause or agreement between the parties. Such provision would expressly authorize the tribunal to decide ex aequo bono, or in other words, the parties' express authorization is prerequisite for deciding on the basis of equity. Now, Lata told about the advantages to deciding of decision of the ex aequo bono. I will a little bit touch critiques relating to decision based on ex aequo bono. The opponents who criticize ex aequo bono principle frequently criticize this clause because of the unpredictability, uncertainty, and subjective imposition of the equity by the arbitrator. Critic of adjudication of ex aequo bono conceive of it as involving diplomatic decision-making more fitting to a legislature than a judicial tribunal. Skeptical of judicial resort to ex aequo bono, one judge from International Chamber of Commerce noted that deciding ex aequo bono introduced the possibility of the law being changed in accordance with the justice and political requirements. The opponents also argued that an ad hoc justice leads to conflicting decision and loss of confidence in a system. Uncertainty involved in the system helped the discrimination and bias to flourish. They also criticized lack of precedential value of the amicable compositor efforts. On the other side, I would like also talk about the advantages of the ex aequo bono very briefly. There are not so many cases in investment arbitration law brought under bilateral and Western treaties. Ex aequo bono principle is mostly used in a commercial arbitration. And first, the main advantages why the parties to the contract decide to use ex aequo bono is the differences between businessmen and lawyers from different legal environment as regard application of national law that may lead to at least strict standard provided for an equity applied by the amiable compositor. Second advantage is that this system can be particularly suitable in the context of a continuing long-term relationship where a degree of flexibility is desirable when the right and obligations of the parties cannot always be determined from the beginning. Third, deciding as amicable compositor might make the dispute simpler time and perhaps also less costly. Fourth, where unforeseen circumstances may occur throughout the duration of the contract, there is more suitable to use the ex aequo bono principle. Fifth, where the parties involved may be more like joint venture than adversaries with a conflicting interests. Finally, equity type clauses can help soften the situation for losing parties. So such adaptability is very necessary in international commercial relations since laws are generally adopted to deal with domestic situation and do not reflect the specific features of international trade. just stand wise to advise the subjectivity of the arbitrator in application of equity or ex bono principle. The parties may make use their right to provide the arbitrators with specific criteria for the decision, either by reference to amicable composition developed in a particular legal system, as my speaker, Mr. Rajat, mentioned, or by referring to some broad notion of fairness, or by including a set of concrete standards to guide the arbitration in reaching their decision.
Thank you, Andrea. Taking it back to the more mundane situation when you have two private parties in a commercial context, in my experience, as a matter of fact, what happens when you introduce during the negotiation period, we're talking about parties from two different countries, of course. When you introduce the notion, yes, we should have arbitration instead of litigation as a dispute resolution system, and there we should authorize the arbitrator to decide the case, if there is one, according to the principle of ex aequo et bono, in fairness, in justice and fairness, in other words. I found when you introduce that notion, and the other side is sort of amenable to considering it, that it has a positive effect on the negotiation itself, because of this notion of what is right standing behind it all. And this is, in the final analysis, in my view, what ex aequo et bono means, to do what is right. And I also found that what is right is a notion and a concept that across nations and cultures is basically the same. Everybody sees when something is not just. So that concept, therefore, I recommend also, because it is very helpful in contract negotiations as far as the atmosphere is concerned. And of course, it does away with this often so tiring dispute during the negotiations, whose law should apply. My law, no, your law, and so forth. It's a waste of time, especially when you're talking about companies that are from jurisdictions that are democracies and that have the same sort of notions. It wouldn't really matter, as a matter of fact, but people have a hard time admitting that, okay, let the contract be governed by the other side's law. And ex aequo et bono, therefore, is the perfect, I would say even a perfect way out of this dilemma. Before we turn to questions and comments from my co-speakers, let me find out, will there be questions so that I have an idea? Okay, thank you. I should also explain that quite recently we organized between INBA and the Munich, Germany-based Court of Innovative Arbitration a cooperation to have INBA also as an institution provide such services, in other words, arbitration among other arbitration varieties, where a sole arbitrator will decide according to ex aequo et bono. Lata, you wanted to, or shall we first? Here's a question.
Yeah, I'll leave it to you.
There was the gentleman there who had a question. Can someone give him a?
As I believe, equity is more of a principle of the common law jurisdictions vis-a-vis the civil law jurisdictions. So in a situation where one party is from civil law jurisdiction, the other party is from a common law jurisdiction, and if the, now ideal situation is that both the parties agree to this principle. But in case the idea, and agree to, as you rightly said, that they agree to do what is right. But in the case where they do not, and how does this principle operate when they do not agree on this principle to operate in the first place, number one. Number two, when the concept of equity is different in two different countries or two different legal systems, civil law versus the common law, and one party is from civil law and the other party is from common law, how does the notion of public interest operate in that scenario?
Can I have permission first?
Yes, please.
Just because we have this equity system in India. See, that is why, precisely because of the question that you've asked, English textbooks on international arbitration have clearly made a distinction between equity and aequos. Now, aequos is a concept that came from the Roman law, which only means trade, fairness, and construction of the contract. Equity in England had come to mean something very different. The Chancellor's Court, the principles of equity were so crystallized that you cannot use the word equity, and repeatedly that's why all international law journals, when they talk of this ex aequo e bono, scrupulously tell you and in express terms tell you, don't use the word equity, because then it becomes, there are certain systems of law like the common law, where they have principles of equity which also rule the roast. So they say that this is something else, this is fairness, the terms of the contract, international practice, international usage, customary law, and to the extent that it doesn't militate against the spirit of the ex aequo e bono, the law of the land, which is decided under the contract. So it is not equity, and I want to emphasize that.
Yes, thank you, Lata. I think that's a very good point to make. And if I may, I just add that ex aequo et bono is a Latin term, and if you translate it, I think the correct translation is justice and fairness. So from that point of view, there should be no problem with regard to public policy. And of course, while ex aequo et bono essentially means not only that the result should be fair, it also means that at first and primarily the arbitrator needs to look at the contract. What is in the contract? What did you mean by this clause and that clause? And interview the parties when there is a problem of understanding. And then, of course, no judge in the world, including an arbitrator in particular, of course, and in particular one that sits in ex aequo et bono, can disregard public policy. So if something is against the antitrust laws, then you cannot go around it or set it off limitations and so forth. So there's always an element or an assurance that a responsibly acting arbitrator, and most do in my experience, will also, by respecting those public policy laws that apply, come to the right result. Who else?
With the permission, yeah, you finish first.
From my point of view, there's already, these two notions are interchangeable. But if I may explain briefly what might be the difference between the equity and ex aequo bono principle, I would say that the feature of both international and domestic law is the distinction that is sometimes drawn between decision based of the law of equity and decision of ex aequo bono. So whereas decision in equity are deemed to be praeter legem, as that part of the law, ex aequo bono decisions are imputed to a kind of extra legal spheres. Maybe the issue is that what differentiates them is also primarily the pronouncement or interference of the arbitrator themselves when they are making decision according to the law or ex aequo bono. So there is no strict division. I agree with Axel. And as for the question relating to disagreement to apply ex aequo bono principle, there are very few cases. Ex aequo bono principle is not very popular in state investment arbitrations. I'm explain later the reasons. But there is one case, ICSID case, which illustrates the resort to ex aequo bono in state investor practice, and it's Ajib versus Republic of Congo. when government of Congo proposed in its country memorial that the tribunal should act as ex aequo bono tribunal, Egypt did not agree. As a result, tribunal considered itself bound to decide in accordance with the applicable law and not as an amicable compositor. Another case which was annulled because there was no agreement in application of ex aequo bono is a famous case, Klockner versus Burundi. So there, if there is no agreement, the parties risk that the award might be annulled.
Thank you.
I just want to supplement what the two of you said. Actually, to supplement what they've said, you know, this public policy, when you enter into discussions on public policy, then you again enter into a very sticky wicket. We know in the Supreme Court judgments of India itself, there are different ways of interpreting public policy. Some judgments say the narrow interpretation is preferred. One says wider interpretation is preferred. It's a huge judicial mess and confusion. Now, to debunk all that, it is to debunk all these domestic aspects of what is public policy, that they have said that in this, I talked to you about that International Center for Settlement of Investment Treaties. They've gone away from all this, and they've said that no such a notion, public policy thing need not be imported, except like he said, the very basic ones which are known and approved by all, like antitrust and some things like that, but not really anything that is exclusive. It doesn't have to have any hegemony of any domestic jurisdiction in that sense. And secondly, when I told you that the award is final, I wanted you to know that the enforcement of the award is not through any other mechanism. The host country of the, which is a party to the award, will have to enforce the award. There's no execution proceeding separately to be taken out in the court, as if it is a judgment of the highest court of the land, which means that you completely give a go-by to the court system and try and resolve disputes by employing this universally accepted standards of ex aequo bono.
In terms of the applicability of the doctrine itself, there is it is a condition precedent. I mean, if there is any doubt between the parties as to its applicability, there has to be an express authorization. And in fact, there is one instance in the Indian context where there was such an agreement, but the arbitrator did not follow the principles of ex aequo bono, and the award was actually annulled on that grounds. So if there is, I mean, that is the reason why the statute itself provides for, if you look at the provision, it says express authorization, and that is not just the Indian standard, it's the standard all over, because as she mentioned, that this is in a sense a waiver. And under law, you have to express yourself, and this needs to be beyond the scope of any ambiguity. So there has to be an agreement. There has to be, as we've heard, that there has to be an application of mind. It cannot be that the fact that you are applying the principle of ex aequo bono means that you do not have to apply your mind or that you ignore evidence. It may be that the technical rules of evidence, the technical procedures and the formalities, which in some instances engender delays, those can be ignored. But at the end of the day, if the intent is right and the objective and the process that is followed is right, then as Dr. Axel mentioned, that this could be one of the ways to ensure an expeditious and commercial way of resolving this.
And this agreement doesn't have to be in the very beginning that you say we'll decide the dispute ex aequo bono. It can also be in the course of the proceedings that you decide that this is going to be very cumbersome, time consuming. So let's keep it out and decide on ex aequo. It can be done even in the course of the proceedings. It doesn't have to be something that should have already been written into the contract or anything like that.
That's very true, and as I think I mentioned earlier, in my practice I have had that happen, that for example during the drafting of the terms of reference under certain institutional arbitration, for example ICC, you start out the proceedings once they have begun by drawing up what they call the terms of reference. Is basically your procedural schedule according to which you will conduct and the parties and the arbitrator have to agree on that, and there you could also, it sometimes works, from my point of view as an arbitrator, that the parties agree to it. There's also, of course, a mixed approach possible. I've had that once where I had to apply or decide the matter first or the issues according to a specific national law, the applicable law, and then see with respect to each result whether that I found that fair. And in this particular case, I found the result under simple application of the law to be fair in all respects except on the cost. The winning party had won by 75%, so the other side was supposed to pay the winning party 75% of its costs, but there I accorded 100% because they had behaved not well during the arbitrations. Well, thank you very much. Unless there are further questions, but again, go on the INBA website and find that there was a press release in April, about this cooperation. This is a tremendous step forward.
And we have you to thank. Congratulations, you pulled off a jackpot.
Well,
really?
It's my pleasure because I enjoy coming here and working with you all and with INBA in particular. And also, by the way, I prepared a paper for today, which was supposed to be on the website, discussing all kinds of arbitration issues. If you're interested, and if it's not on the website, just give me your card and I'll mail it to you. Would be my pleasure. Well, I thank you, my fellow panelists, very much for your contributions. And I thank INBA for giving us the opportunity to present this panel.
Thank you, panelists. And we'd like to do a small round of appreciation for this presentation. Rajat, will you kindly do the honor? Shashank, will you kindly do the honors, please? May we have a huge round of applause, please. Thank you. And last but not the least, the moderator. And a group photograph, please. Shashank, please be there. Okay. Yeah. I'll also.
Yeah, please.